Good afternoon, everyone. Welcome to today's webinar regarding the notice element in premises liability cases in Michigan. My name is Justin Cole. I am a partner in the Grand Rapids office of Secrest Wardle. This afternoon I'll be taking a few minutes to walk through and explain some of the issues that I feel are often overlooked in the defense of premises liability cases. Oftentimes we find in practice that the notice element is often underanalyzed and underlitigated from a defense perspective. The analysis is extremely fact-sensitive and deals with, among other things, the type of the condition involved, who caused or contributed to the condition, when did the condition form, how long did the condition exist, what caused the condition to form, when did the premises owner or possessor become aware of the condition, and should the premises owner or possessor have known of the condition. Importantly, in Michigan, in premises cases, a plaintiff is required to establish these facts for notice to be found and, ultimately, for liability to attach. Generally speaking, Michigan follows the restatement of torts. Duty in premises cases rests on two sections of the restatement. As seen on the slide here, Section 343 states, "A possessor of land is subject to liability for physical harm caused to his invitees by a condition on the land if, but only if, he A. knows or by the exercise of reasonable care would discover the condition and should realize that it involves an unreasonable risk of harm to such invitees, and B. should expect they will not discover or realize the danger or will fail to protect themselves against it, and C. fails to exercise reasonable care to protect them against the danger." And secondly, the restatement of torts at Section 343A1 provides that a possessor of land is not liable to his invitees for physical harm caused to them by any activity or condition whose danger is known or obvious to them unless the possessor should anticipate the harm despite such knowledge or obviousness. This is essentially the open and obvious doctrine with which you are all probably familiar. These sections in the restatement of torts each pertain to invitees. Most often, plaintiffs in the premises cases are classified as invitees who are owed the highest standard of care. The plaintiff's status triggers the level of duty owed. Generally, there are three categories that apply to visitors. First is the invitee, which include, among other things, guests at restaurants, businesses, and apartment complexes. Second, licensee, which is essentially a social guest. And third, a trespasser. Each is owed a different and varying degree of duty. An invitee is either a public invitee or a business visitor. A public invitee is a person who is invited to enter or remain on land as a member of the public for a purpose for which the land is held open to the public. Generally, a business visitor is self-explanatory and is a person who is invited to enter or remain on land for a purpose directly or indirectly connected with business dealings with the possessor of the land. In Michigan, an invitee is owed three duties: a duty to inspect, a duty to warn, and a duty to protect or make safe. The duty of care owed by a premises owner or possessor to an invitee is summarized as follows. Premises owners have a legal duty of reasonable care to protect their invitees from unreasonable risk of harm caused by a dangerous condition they know or should have known the invitee would not discover, realize, or protect themselves against. The licensee, a social guest, is owed a lesser duty of care. Landowners have a legal duty to warn licensees of dangerous conditions on the land which the owner knows or has reason to know if the licensee does not know or have reason to know of the condition. In other words, a landowner only owes a duty to warn licensees of hidden, known dangers. And, unlike an invitee, a landowner does not owe a licensee a duty to inspect the premises or to make the premises safe for the licensee. And finally, we have the trespasser, who is owed very little duty, if any. Defendant landowners generally have no duty to trespassers to notify them of any condition on the land. However, landowners may not actively injure trespassers in an effort to keep them off their property. You hear the cases involving landowners who install spring-loaded guns, hidden traps, and covered pits. These items, and others like them, equate to a landowner actively taking action to injure trespassers in an effort to keep them off of their property. Liability will certainly attach in those instances. However, in Michigan, we also have an exception for child trespassers. There is a duty to landowners for child trespassers if the condition may be considered an attractive nuisance. Liability may exist for an artificial condition on the land if A, the place where the condition exists is one upon which the possessor knows or has reason to know that children are likely to trespass. B, the condition is one which the possessor knows or has reason to know and which he realizes or should realize will involve an unreasonable risk of death or serious bodily injury to such children. C, the children, because of their youth, do not discover the condition or realize the risk involved in meddling with it. D, the utility to the possessor of maintaining the condition and the burden of eliminating the danger are outweighed by the risk to the children involved. Essentially, this is a balancing test. And finally, E, the possessor fails to exercise reasonable care to eliminate the danger or to protect the children. Importantly, in situations involving child trespassers, all 5 of these elements must be met for liability to attach to the premises owner or possessor. Although the plain language of this doctrine indicates that it only applies to child trespassers, the Michigan Court of Appeals has held that child invitees could potentially fall within the category of children protected under the attractive nuisance doctrine. It is also important to understand that this doctrine extends only to those who both possess and control the land. While a defendant's duty generally will end at the boundary of his or her property, this duty may be extended to conditions on adjacent property, but only if the defendant has exercised possession or control over those adjacent properties. A few examples of attractive nuisance cases illustrate this point. In Rand versus Knapp shoe stores, the landlord, tenant of a building, was not required to take any action with respect to an alleged attractive nuisance of a curb between the sidewalk and alley, which was used by children as a bicycle jump. In Byrne versus Schneider's Iron and Metal, a landowner was found responsible for a nearby construction site that he knew that children were attracted to a sand pit under the attractive nuisance theory. That has been allowed. In Pippin versus Atala, the property owners who own a parking lot subsequently chained off an area of the parking lot where bike riders routinely used a path which led through the parking lot on one end and exited at the other end. Within hours of the chain being placed on, the plaintiff ran under the chain on his bike and suffered a significant and severe head injury. The court found that the defendants knew that child trespassers used the bike path. The court found that this would be a question of fact for the jury and could conceivably constitute an attractive nuisance. Obviously, the attractive nuisance cases are extremely fact-oriented. The knowledge of the defendants always seems to be a necessary key to these cases. If a child trespasser is injured and the defendants, the property owners, generally know of children trespassing on their property for the use of a certain purpose, they may be held liable depending on the type of condition which is involved. More specifically, courts tend to focus on the actions of the plaintiff and if the plaintiff child actually had a significant role in the condition being dangerous. Now, moving on to some common examples of the defendant's duties involving business invitees. With respect to items or debris on floors, aisles, or other conditions in stores, generally speaking, it is the duty of the storekeeper to provide reasonably safe aisles for customers, and he is liable for injury resulting from an unsafe condition either caused by the act of negligence of himself or his employees, or if otherwise caused, wherein known to a storekeeper or has existed a sufficient length of time if he should have knowledge of it. That is essentially the constructive notice element. Constructive notice arises not only from the passage of time itself, but also from the type of condition involved. Or, in certain situations, it could be a combination of the two. Constructive notice can be proven with direct or circumstantial evidence. In these cases involving items on floors, aisles, and other conditions in stores, Michigan courts tend to stress the plaintiff's and the defendant's knowledge of the surrounding area and the conditions of the premises, as well as the circumstantial evidence to establish how long or how short a time the condition may have existed. If it is found that the condition existed for a significant period of time, the defendant could be deemed to have constructive notice of the condition. On the other hand, if the condition was only present for a very short period of time, no such constructive notice would be found. Another common example that we frequently see are cases involving snow and ice removal. In these cases, a business invitor is required to take reasonable measures within a reasonable amount of time of the accumulation of ice and snow to diminish the hazard of injury to an invitee. And here on this slide, we have a case where the plaintiff failed to establish constructive notice of icy conditions. In that case, the evidence confirmed that it had not snowed for several days, it had only rained a few hours before reverting to freezing temperatures, the ice patch on which the plaintiff slipped was only the size of 2 parking spaces, and no other person, including the plaintiff, had observed the ice before the fall. Under these facts, the plaintiff was unable to establish constructive notice on the part of the defendant. In fact, more recently, we've seen that black ice claims often fail for these very same reasons, lack of constructive notice. It's also important to recognize that the notice requirements, either actual notice or constructive notice, also apply to the statutory claims brought under the Landlord-Tenant Statute, MCL 554.13, which I'm sure you're all familiar with. In many of those cases, the plaintiffs and their lawyers simply point to the presence of snow or ice on a parking lot or a common walkway, which they suggest automatically triggers a violation of the statutory duty. Oftentimes they overlook the fact that they must still establish that the premises possessor or landowner had knowledge of the condition on which the plaintiff fell. Criminal acts of third parties have a different analysis altogether. Generally, merchants have no obligation to anticipate the criminal acts of third parties and are not obligated to do anything more than reasonably expedite the involvement of the police once criminal activity becomes apparent. These cases, however, are extremely rare, primarily due to the fact that the law is very clear that landowners and premises possessors have no duties or obligations to anticipate criminal acts of third parties. When evaluating a premises liability case, and in particular the notice element, there are 9 key issues that we recommend be focused upon. These were touched upon briefly earlier. First, what condition is involved? Second, did the store owner or store employees cause the condition or contribute to it? Third, did the store owner or employees know of the condition? Fourth, when did the condition form? Fifth, how long did the condition exist? Sixth, should the store owner or employees have known of the condition? 7, the frequency of the condition or of similar conditions on the premises, including the location. 8, who or what caused the condition to form? And 9, when did the property premises owner become aware of the condition? Oftentimes, these issues are focused on at the plaintiff's deposition, and when the questioning is narrowly crafted, it's often the case that the plaintiff does not have the information to answer these questions. And this is important, and that lack of information can be used effectively at the motion phase to perhaps dismiss a claim based on lack of notice. In defending premises cases arising from dangerous conditions on the land, we recommend documenting, if at all possible, the following: how the condition came to be, when the condition began, when the condition ended. We recommend that the area be photographed if possible, when the area was initially inspected, methods of reporting, and we recommend that workers and witnesses be documented, including their names and addresses if possible. This information and documentation can be used in litigation to establish lack of notice and to show that reasonable measures were in fact used after defendant became aware of the allegedly hazardous condition. There is also another issue that frequently arises in premises liability cases, especially when the notice issues are in question. This relates to the element of causation, proximate causation, or cause in fact. In premises liability cases, the plaintiff must present evidence linking a specific defect or condition on the premises to the injury-producing event. Speculation and conjecture is insufficient in this regard. The mere occurrence of an accident in and of itself on land is not sufficient to establish a genuine issue as to factual causation. In fact, there are many Michigan cases out there where the Michigan courts have rejected claims of landowner negligence where the plaintiff was unable to demonstrate with any specificity the cause of the injury. That concludes my brief presentation on the notice issues in Michigan premises liability cases. Unfortunately, I am not available at the moment to answer live questions, but feel free to call or email me with any questions, comments, or if you'd like further information regarding any of the issues contained in this presentation. Thanks again.